Mr. Chairman and committee members, good afternoon. My name is Carol Perel Cocheres, and for the past 37 years I've been a Pennsylvania lawyer, having graduated from Duquesne University in its law school in 1975. After my law school graduation, I came to Harrisburg and then served for 8 years as an assistant counsel with the Pennsylvania Department of Community Affairs, commonly called DCA, under the administrations of both Governor Schaap and Thornburg. I mention DCA in part because DCA is one of the predecessor agencies to the Department of Community and Economic Development. From DCA, I entered into private practice in 1984. And then in 1986, I joined Eckert Seamans Public Finance Group. And for over 25 years, I was a partner in the Harrisburg office of Eckert Seamans. In 2010, after a major reconstruction of my back at Johns Hopkins, I retired from Eckert Seamans on medical disability and currently am of counsel to the firm. As a result of my back problems, if this goes on for a long time, I may need to ask for a break to get up at some point. But anyway, I beg your indulgence if that happens. Eckert Seamans is a highly respected Pennsylvania-based law firm, headquartered in Pittsburgh. Eckert maintains offices throughout the Commonwealth, including Harrisburg, and throughout the eastern United States. Eckert employs more than 340 attorneys and represents clients in virtually every area of the law and prides itself on its professional integrity. During my tenure at Eckert Seamans, we represented the Harrisburg Authority as bond counsel in connection with the 2007 retrofit completion financing, as well as we served as underwriters counsel for the 2003 retrofit financing. In connection with the 2007 retrofit completion financing, our responsibility as bond counsel was to work with the authority, the city, the financial advisors, and the underwriters so that the proposed completion financing was in compliance with state law, in particular the Pennsylvania Municipalities Authorities Act and the Local Government Unit Debt Act, and as applicable federal law. We also rendered opinions on the legality of the notes and of the city guarantee. We fulfilled our responsibilities under the 2007 retrofit completion financing professionally and competently. We did not make any public policy decisions regarding the issues, including the decisions to issue any bonds or to make any guarantees. Rather, we assisted in the execution of policy decisions made by the elected and appointed public officials. In 2010 and 11, as you know, there was a review of these financings and other matters was conducted by Clure, Harrison, Harvey, Brandsburg, LLP, and Parenti Baird, LLC, at the request of the Harrisburg Authority. During the course of that review, Eckert Seamans, along with other law firms, financial advisors, and other entities, was requested to produce work papers and other documents, as well as to have professionals in the firm interviewed by the attorneys representing the authority. Eckert Seamans produced thousands, and I mean thousands, of pages of documents requested by the authority's representatives regarding the 2007 financing. I also voluntarily agreed to be personally interviewed by the authority's attorneys and was interviewed for several hours. Although other firms may have refused to produce documents or appear for interviews, Eckert fully cooperated with the review to the extent allowed by attorney-client privilege to other clients. As a result of our cooperation, the authorities' attorneys had full access to all the documents they requested of Eckert Seamans, as well as to my personal recollections. However, the report omits mention of many facts that I related to them, as well as documents that were produced by the firm and given to them. Finally, as of October 17th, 2012, the Harrisburg Authority has waived its attorney-client privilege with us for me to be able to appear at this meeting. I am prepared to answer any questions that you may have, Senator, and of your committee, and I thank you for the opportunity to appear here today.
Thank you very much. Senator Fullman, you have some questions?
Ms. Cocheres, thank you. Who prepared the bond documents for the incinerator financings? Did the bond documents contain standard provisions for a revenue financing? And if not, how were they different from the standard provisions?
Okay. Let me make a distinction here between, we were underwriters counsel for the 2003 transaction, okay, and prepared the official statement for the authority and the city and the county. That's really their documents, but we prepared and organized the document. For the 2007 financing, we were bond counsel. Now, for the 2003 deal, the bond counsel for that transaction, which was Obermeyer, prepared the relevant bond documents, whereas in the 2007 transaction, where Eckert was asked to serve as bond counsel, we prepared the documents relating to that transaction, the note documents, the indenture, the guarantees, and so forth.
Well then, with the 2003 in mind, then, did you, what's 2007? No? Excuse me.
Okay.
Did you believe the 2003 debt to be self-liquidating?
Okay. I hate to sound like a broken record with other people that have said this earlier today, but there is a sort of a compartmentalized view of this. In 2003, our firm did not prepare the self-liquidating debt report. As attorneys, we're not qualified like engineers to put together the numbers and the estimates that are required for a self-liquidating debt report.
Then what about 2007?
Okay, 2007, the 2007 debt was not qualified as self-liquidating. There were no exclusionary proceedings submitted to the Department of Community and Economic Development for the 2007 debt.
Could you explain that?
Okay, maybe I should give you a little bit of background on what self-liquidating debt is. That might help with the situation here. Okay. As one of my partners frequently states, self-liquidating debt has like 4 premises. 1, you need to have a facility constructed. 2, that facility has to be operating. 3, the facility has to be generating revenues through charges, fees, and other assessments. And 4, there has to be a rate covenant where the authority or issuer has the obligation to raise rates in order to produce revenue sufficient to pay operating expenses and debt service. I think what you're leading up to is you haven't said it, but I'll take a guess, and this will be a long answer, is you're looking at the Section 8110B certification.
Correct.
Okay. That particular issue it's a long story, but I'll go through it. Okay. In May of 2007, our firm was asked to become bond counsel on the retrofit completion transaction. As with any other transaction, the first thing we investigated and reviewed was whether the transaction would meet state and local law. And as I mentioned earlier, Municipalities Authorities Act, as well as the Local Government Unit Debt Act. I know, just as an aside, the report does not really get into the Municipalities Authorities Act and its application here. But we did that, and one of the very first issues that came up, and it was also recognized by the other members of the financing team, was what to do, how to address the 8110B certification. So in our review and our analysis, we checked the legislative history, of which I have significant amount personally, since I was at the department back when the 72 Act was amended in 78, 79. The case law, the decisions that are issued by the department whenever a challenge or a complaint is submitted to the department, and of course a review of the statute. There was a dearth of guidance. There just really wasn't anything there to deal with what we had in front of us in 2007, which was a partially completed project that the public officials at that time wanted to have it completed. So by the first week of June, I contacted Bernadette Berrettini at DCED. I explained to her the situation, the status of the project, that there were issues on cash flows in the past, but we were looking also into the future, and this new financing for the completion of the facility was supposed to provide the sufficient funds to complete the project, as well as to eventually self-liquidate the project. There was so much fluidity at that time, and I'm talking at this point still in June, July of 2007. There was so much fluidity, which I explained to her, that there were discussions of selling the facility. There were discussions on raising rates for both the city residents and the county residents. And so when we laid this all out, and I told her that I thought that the new debt that we were talking about, both the new debt looked like it was going to have two components: the working capital component and the construction component. That both of those components, the debt that would be incurred, would not be qualified as self-liquidating, and that the remaining debt, in my discussions with her, it seemed as though it was going to be acceptable to DCED that since this was a non-completed project, that the outstanding 8110B certification could remain in place until such time as the project was completed, and if at that point it appeared that some of the debt would not be self-liquidating, which most people thought that there would at least be a portion of the outstanding debt at that time would probably not be self-liquidating at the end, that could be taken, the adjustment could be made to the debt statements and to the city's debt capacity at that time. So we proceeded on that reliance then through the rest of the summer and into the fall of 2007. Now, in the fall of 2007, there was a new board at the Harrisburg Authority. We were, again, reappointed or asked to stay on by the chairman of the authority. As he said to me, that he knew I was a straight shooter, and he asked me to continue with the project. And we moved on, and at that time, in the fall of 2007, PFM, Public Financial Management, was engaged, as well as the engineering firm of HDR. And those two parties were to review and to, I would say, analyze the reasonableness of completion of the project, and look into what revenues might be generated, and so forth. And by the fall of 2007, PFM had put together different options that would show how the outstanding debt would be paid, how the new debt might be paid. There was going to be a reserve for like the CIT financing and so forth. And PFM did, in fact, give us, and the public officials were given copies of these various options that included showing that the debt could be self-liquidating, that there were estimates and projections to that effect. And I think one thing that's been missing in this hearing, and is missing in the audit report, is this concept of, when you're talking about self-liquidating debt, you're still always talking about estimates. There aren't guarantees when you deal with self-liquidating debt. It's a look into the future of the project, and it's not a look back historical evaluation. And so in the fall, we did have numbers. I did mention this to the auditors, and that was one of the omissions that the auditors made, is that they said in the audit report that projections that they had found in our document, they did not find any projections in our documents that showed that the debt was self-liquidating. Well, I have for the committee a copy of an email that was in fact sent by our firm counsel, and I'll give you a copy of this, to Doug Schleicher, pointing out to them that we gave them one particular public financial management presentation on the working capital loan that was dated November 13th, 2007. We referred to, I'll give this to you, thank you. We referred to the documents, all the documents were numbered under a documentation system. So it referred to that particular item, which I gave you a copy of, plus we gave them a copy of the May 8th, 2008 financial update, again being put together by Public Financial Management. And this particular report I'm bringing up to you, and it was sent to Mr. Schleicher to show that the authority had the intention of, in fact, making the debt self-liquidating, and they were planning to, this was a direction from the chairman, James Ellison, that the debt service through 2008 was all covered for all the outstanding debt. The debt service starting in 2009 was not covered. And James Ellison and the other authority board members had said that they wanted to have the rates pay for the debt service in 2009. And so PFM, Covanta, HDR all worked on numbers in 2008 to have the debt be self-liquidating on the basis of the rates, fees, and charges being charged to the customers of the facility. And I wanted to bring this to your attention, that the fact that there was an attempt by the authority to have the debt be self-liquidating, that was an omission in the report. Now, the problem that occurred was that the authority raised the rates, which resulted in the city raising its rates per ton. However, when the authority attempted to raise the rates of the county customers, the county challenged that rate increase under the solid waste disposal agreement that ran between the authority and the county. And for the authorities, unfortunately for the authority lost the arbitration. And so that was what's caused some of the issues here, because of the big differential in rates between what the city residents are charged and what the county residents are charged. I hope that gives you a little bit better picture of how what the approach was and what was done in 2007 as to the Section 10, the 8110B. If you have further questions.
I have just one more question for you, ma'am. Who advised Mayor Reed and Commissioner Hayes to sign the 8110B certifications that the existing incinerator debt was self-liquidating?
Well, I think by the time we were in the fall, November of 2007, and by the way, the officials had been made aware of the issue of self-liquidating debt, like throughout the process here. By the time we hit the fall, there were options that PFM and HDR and so forth had put together that showed that the outstanding debt could be self-liquidating in the future. And as I mentioned to you earlier, self-liquidating debt is not just a historical examination. It's also a prospective examination. So we, by the way, in the fall also, I had a second conversation with DCED to confirm again that the approach that was being taken was in fact acceptable to DCED, because the last thing we wanted was to send proceedings up to the Department of Community and Economic Development and have them rejected because there was something wrong with the certificate, or they didn't agree with the fact that even though there were financial difficulties with the incinerator, that the 10B certificate could still be executed by the respective, well, I worked with the city. I can't tell you, and we sent the certificate over to Mayor Reed, which he executed. I do also want to point out to you that the ordinance, guarantee ordinance, was very explicit, and I don't know if you have seen the actual ordinance. It appeared as though from the last hearing that you hadn't seen how explicit and detailed the guarantee ordinance actually was. And in the guarantee ordinance, there's very specific language on all the difficulties that the incinerator was having, losing money. There's a 5-page, single-spaced recitals of the project going back to 1993, and bringing up about the termination of Barlow, the failure to complete the retrofit bonds project, resulting in delays and losing, not being able to operate efficiently, not being able to generate anticipated revenues, and so forth. A big description of the project, the two components of the financing, which I mentioned earlier, Also, there's mention in here that it's anticipated that the authority wasn't going to be able to fund certain debt service payments. That's all mentioned in the 5-page preamble alone. And then every single penny of the $30 million working capital loan is set forth in Exhibit D to the facility. Everything that was to be spent, all the reimbursements to the city, the county, payments for operating expenses to Covanta, payments of monies that the authority owed on water and sewer with respect to the incinerator, the cost to issuance. So this was an extremely complete set of proceedings that was sent up to DCED. If DCED had problems with the 10B, the 8110B certification, and I think that's telling because there have been other challenges to city projects by city residents if they were concerned with the project. There had actually been one back at the beginning of the incinerator acquisition back in like '93, and then there were a couple objections to parking bonds in connection with the South Street garage around 2000, 2002. So it wasn't unheard of for citizens to take a challenge, and here no challenges were made. And then under the Debt Act, there's also the ability for an individual or resident or party to challenge DCED's approval of the project up to the Commonwealth Court, and no challenges or appeals were made to the Commonwealth Court. And I guess I had one more admission. I thought that the report, and it's related to self-liquidated debt also, and this whole risk issue, is that back in 2007, there were tremendous number of meetings, both public meetings and working session meetings of all the public and appointed officials. There were numerous city council committee meetings. There were regular city council meetings. The Dauphin County Commissioners had meetings. There were working session meetings. All the public officials knew what the situation was. And this report also fails to mention that of the public officials and appointed officials, you had the mayor approving it. 6 of the 7 city council members approved the financing. All 3 of the county commissioners approved the financing, and 2 out of the 3 voting members of the Harrisburg Authority approved the transaction. However, the report doesn't mention all these comments I made about all of the publicity, public input, and so forth that occurred at that time in 2007. So I might have given you a long answer to your questions, but I'm trying to also bring out some of the things that were omissions in the report.
And I appreciate that and such, but I asked this earlier before the lunch break, and I forget who it was, but with all this happening and all these experts and full disclosure and everything else going on, who was actually driving the train?
Well, in 2007, the public officials and appointed officials were driving the train.
Right.
They made the decisions to complete the facility.
Would you know who in particular?
Yes, the mayor, the members of the 2 authority board members, and the county commissioners. all made the decision that it was better to complete the resource recovery facility project than to have $225 million of stranded debt.
Okay.
And the report, by the way, also doesn't say if what would the situation be now if the facility had not been completed.
Okay. Thank you.
Thank you, Mr. Chairman. Thank you, Attorney Cocheres, for your thorough testimony and for your professional account of these proceedings. And I hope your back is feeling better.
Thank you.
I only have one question, really, and I think I agree with you, and I've already said it on the record in these hearings that I think the forensic audit, while an extraordinarily valuable piece of information, is not full information, and there are certainly other things to inform our thinking here in this testimony. But they do raise one concern in the audit. I wonder if you would address directly, and it really has to do with what you just described as a very thorough project description, and they question the ability to borrow for interest payments on 98, 2002, 2003 debt as a cost of the 2007 project because you grasp it as a whole, even though there are individual transactions along the way. I guess what I'm trying to get to on this, Attorney Cocheres, is what I heard at the previous hearing about the unique nature of this project. Even talking to others who had done bond counsel across the state, there was a distinction here that differentiates it from your standard sanitary waste authority project and others because of the dynamics and the complexities associated with its operations, the relationship between the city and the county, et cetera. And I'll give you a chance to respond. But this, even DCED, I think, and I used to work at DCED, and by the way, I worked at DCA as well. But the thing is, I think even they were making an interpretation about this as something distinctive. I asked Attorney Veratini, had you seen something like this? And her response was, no, this is kind of unique. Is that your assessment as well?
I wouldn't say it was totally unique.
Okay.
It was different than the incinerator project is different than a water and sewer project to a certain extent. But at the same time, too, the incinerator project is still subject to the same rate covenants that are in effect for water and sewer projects. And one thing on the debt service and the working capital, that payments that were included in the 2007 transaction, going back to covering the 1998 and the 2002s and the 2003 ABCs and DEs and Fs, that was as project cost under the Municipalities Authorities Act as well as the Debt Act. They fell within the parameters. Okay. And in fact, there's no mention in the audit report of the Municipalities Authorities Act right at the beginning of the purposes section of the Municipalities Authorities Act. The very first item listed that authorities can borrow for is working capital in that list. And then they have a list of particular type projects that can be undertaken by municipal authorities, and there's specifically listed incinerators.
Okay.
But anyway, the working capital components, which were for operating expenses and capitalized interest, we believe all fell within the definitions under the Municipalities Authorities Act as well as the Debt Act. And like I said, the ordinance was very clear about what the proceeds of the working capital loan were to be used for.
Understood. Thank you. The only other, and by the way, your testimony is completely consistent with DCED with respect to the certification, and I think your testimony also affirms some other testimony we've gotten in both of these hearings regarding the nature of the reliance on projections in order to fall within the purview of self-liquidating, the definition, the attributes that you point out. So I guess my question is this, again, related from a forward-looking perspective. Are there any ways for us to mitigate the risk of the kinds of failure and projections that we witnessed here?
No, I don't think so.
No.
Because what happened here, and this is also what I heard some of the other people testify to, what happened here was the implementation of the financings, not the financings themselves. The implementation of the project by Barlow and the project people is what caused the problem here, not the financings.
Understood. Thank you very much, Chairman.
In the 8110B certifications for 2007,
Okay.
so did you prepare those?
Our firm prepared the one-page sheet, 8110B certification, yes.
Now, I'm confused here. You talk about looking forward when you do an 8110B.
It's also looking forward because to a certain extent, yes, if there are economic problems, economic deficiencies occurring that look like they are going to be continuing, then there has to be a determination of if whether all of a particular outstanding bond issue is now no longer self-liquidating, or a portion of that bond issue is no longer self-liquidating, and then appropriate changes have to be made on a debt statement when the debt statement is submitted to the Department of Community and Economic Development. However, when there's here in 2007, it was understood that there was going to be a fix here. I mean, the project was going to be completed, and that going forward, that most, if not all, of the outstanding debt would eventually, if not, when I say eventually, because in 2008, there were monies being borrowed to pay the 2008 debt service, which was permitted under the Debt Act and under, well, okay, just permitted under the Debt Act. But in the future, it was expected that there would be sufficient revenues to be self-liquidating. And there was still the option that if the project still didn't work out, even after the completion financing, the city and the county could make adjustments to their debt statements and presented to the department. If this project was totally complete, the big difference here, it was the fact that the project wasn't completed, and there was an expectation that the funds being borrowed would result in the project being operational and paying. That's that's the view that was taken in 2007.
Okay, if I can put these pieces together, the way I understand this is, at that point in 2007, the project was way behind schedule, and the schedule that was initially drawn up by Barlow and accepted by everybody was blown. And the certifications that were made at that point, as I read them, actually look back, not forward. They certify that the debt of the city or the county previously excluded as self-liquidating, credited, or as subsidized. No decrease in the amount to be excluded is required by any change in circumstances other than decreases resulting from the payment of bonds or notes. So except for the money that they've paid off, nothing else has changed, but in fact it did change.
But because the project was not completed.
Because your conversation with Ms. Berrettini said that
the project wasn't.
That it was one continuous project.
Well, we presented it to DCED that there's been one continuous project really going back to 1993, because when the Harrisburg Authority acquired the facility from the city of Harrisburg in 93, at that point, there was in the resolution and in the documents the intent to retrofit the facility. And I think back in 93, there was money for engineering purposes to start this project, this retrofit. As Mr. Giorgione stated, it was a 10-year process to get to 2003 with getting the retrofit in place.
That might refresh his memory. I had asked him a question about the questions raised by Ms. Berrettini, and that was, I think, that was what I was referring to, and I found the series of emails that ultimately were answered by you that, or no, they were answered by him, by Andrew Giorgione. This issue is resolved. Carol and I spoke with Bernadette, and she has all the info she needs in the existing SLDR. What's SLDR? Yeah, self-liquidating debt.
Debt report.
And those were the conversations and went back and forth about, she was questioning the time where there were cash flow issues.
I think if I remember correctly on that, and I'm not quite sure, I'm a little fuzzy, but I thought that there was the projections originally sent up were 5 years instead of for the 20 or 30 year term of the bond issue. And one of the reasons why I know Mr. Giorgione asked me to be on the phone and to contact Bernadette is because of my past position up at the DCED, and that I knew Bernadette and actually like introduced Bernadette to him in the phone conversation. So what was essentially done is that the full projections were presented to the department.
Well, as lawmakers, we're trying to figure out what we can do to make things better. So you're explaining to us that really all the problems that we've seen over that long period were acceptable under the law because the project was considered, since it was started when the city took over the incinerator, it really was one very, very long project. And even though it had all these various smaller projects as part of it, it was considered one large project under Laguda.
That is the way it was formulated from really day one and through each of the individual financings. And if you go back and you look at the 2003 guarantee ordinance, it was viewed as one long project, as well as in our 2007 ordinances. We referred back to 1993 and the retrofit and the fact that there was a failure of the retrofit in 2003 with the 2003 bond proceeds. You know, there was a failure there of that particular project.
Well, that's discomforting to me to see how, you know, when projections aren't met and we see the cash flow issues over that entire time, and that we allow that to continue to happen really unchecked. I mean, it just continues to be recertified that everything is continuing and we're still working on it, so give us more money and allow us to incur more debt for our taxpayers in the city and in the county, and we'll eventually work our way out of it. I mean, that's
but those were decisions,
not very comforting.
Those were decisions made, policy decisions made by the county and city officials.
I understand it was, you weren't signing your name to that, but I mean, it involved everybody that was involved in the project. But I'm saying under the law, apparently under the law, we allowed that to happen. I mean, if they were, whatever we're doing, as long as it was one continuing problem, apparently we're still allowed to go ahead and borrow more and more money and try to work our way out of that. I mean, most banks wouldn't allow a private business to do that. They would say, well, that's enough, you're shut off.
Well, even under the Municipalities Authorities Act, the definition of working capital is broader than what's under the Local Government Unit Debt Act.
And
So
that's-
even if you
yeah.
wanted to say that each of these financings was a separate project under the Municipalities Authorities Act, monies for working capital and debt service could still be borrowed under the Municipalities Authorities Act.
Well, I think that's problematic as well. I mean, the definition appears to include all the guarantee reimbursements, debt service, any special projects that money was pulled out of that for special project funds. I mean,
There were
those
no
things,
special project funds in the 2007 transaction.
you don't know about before that, though.
I don't know what happened I don't know about the special project fund early in 2003.
Would your firm be paid if that deal didn't go through in either 03 or 07, both cases?
No, which is typical in public financing.
Can you explain to me, too, I'd asked this to somebody earlier, the waterfall of payments that are made so that, what I'm trying to understand is how the city and county continued to get their money back after they made payments, and then when refinancing was done, they were paid first.
Okay, I think the biggest distinction that's not really clearly mentioned in the report is that the 2007 working capital financing was not secured by any revenues from the resource recovery facility. That $30 million transaction was secured solely by the guarantees of the city and the county. And under the reimbursement agreement that had been mentioned earlier, the prohibition against reimbursing the city and the county for guarantee payments were from monies from the actual revenues being generated from the facilities. And bond proceeds, bond proceeds themselves aren't revenues, receipts and revenues under the indentures.
That's the 2007.
Right, definitely the 2007, right.
Okay, I appreciate that. I didn't understand that. Did you have another one, Mike?
I just have a couple follow-ups. You just said that you say that these policy decisions by elected officials were made by the elected officials, but yet the elected officials tell us that they relied upon the professionals to ensure that there were sound policy discussions. How do we rectify these two positions with one another?
I don't know.
Because as an elected official, we're going to be going to various experts and hopefully that we're giving sound advice, but yet, I guess in full, I don't get it.
The problem with the Harrisburg Resource Recovery Facility, as I mentioned to you earlier, occurred through the implementation of the construction project and the failure of Barlow to complete that project. That's what caused this whole problem to blow up.
Okay, well then I'm going to ask you this question. Bruce Barnes earlier testified and said that the city's self-liquidating debt certificate was poorly done. As your firm drafted the certificate, how do you respond to that?
Okay, we did not draft, okay, I don't know which self-liquidating debt certificate he's talking about, but the 2003 self-liquidating debt certificate was drafted by Barlow. The attorneys didn't draft that certificate. Any comments that attorneys made on a cover letter, to that certificate, were made to just reference back specifically to the Debt Act language under Section 8026. And even the report speaks to the attorneys only made minor comments to the self-liquidating debt report, and it was just on that first page of the certificate. The rest of the report itself, there's like a page and a half certificate that matches and corresponds to the language in 8027, Section 8027 of the Debt Act. And then attached to that certificate is the engineer's report, which was prepared by the engineers. And in the 2003 situation, bond issue, that was prepared by Barlow. That was not prepared by any of the attorneys.
Earlier, I asked you the question, who was driving the train, and you said, of course, you said the mayor, and then the authority, because you said 2 of the 3 authority members voted on this, and of course the county commissioners. I know who the mayor is, and I know who the county commissioners were. But could you tell me who the 2 authority members were?
James Ellison and Erica Bryce.
Okay. And then one last question, and thank you for that. Eckert Seamans charged a fee of $300,000 plus costs as bond counsel for the 2007 C&D notes. Is $300,000 a normal fee for the $30 million bond issue, and what was the basis for the charging the $300,000?
The basis for the charging of the $300,000 was the tremendous number of hours that we put into the project. The 2007 financing was not a typical $30 million project. We spent hours and hours on the project, going to meetings with all the different officials, both appointed and elected, the other financing team members. Someone told me that our hourly rate by the time we finished it probably only came down to about $235 an hour for that particular financing.
Was it just Eckert Seamans? Because the other professionals can't seem to remember what they were charged. Am I right? Yeah, because no one has been able to give us any background on any of this. You have, so it was just Eckert Seamans that.
Well, because I prepared for today's meeting and checked out what we charged in 2007. There's also a mistake in the audit report about how much money the firm made in the years 2003 to 2010. It speaks to as though we made $3 million over those years, and that's incorrect. One thing we'd like to point out is that our firm ended up, I guess I should take this back, maybe explain it a little bit better here. The law firm of Wolf Block was handling the Harrisburg Authority's lawsuit against Barlow's insurance company. It was a contingency fee matter, and Barlow, there was a settlement, and as the authority received several million dollars, and then the Wolf Block team would have gotten the contingency fee payment. Wolf Block was dissolving, and the attorneys from Wolf Block that worked on that project, at least one of the attorneys that worked on that litigation, came to Eckert Seamans. So when the payment came on the contingency fee, it came to Eckert Seamans, but the authority knew that only 1/3 of that payment of $1.8 million was going to Eckert Seamans, and the rest had to go to whatever remained of Wolf Block, and then there was another law firm that a Wolf Block attorney went to. So the amount of fees we earned from 2003 to 2010 was not $3 million, but it was $1.8 million over that time period. Is there anything else that
How about one final one from me? I asked this to a couple other people, so let me ask you. I'm just trying to get my hands around the ethical obligation of an attorney at law in that situation, and I use a little bit more dramatic example. If I'm laying on a gurney after a bad car accident and I tell a doctor that my wrist really hurts, and he sees that one of my legs was torn off in this accident, he's not going to just treat my wrist and say, well, all he asked about was my wrist, so that's all I looked at. I can't understand with all these problems why somebody in the system didn't come forward and say there's some foundational concerns about how tight this schedule is. This is untested engineering here. There's no performance bond in place. The city's financial position isn't good. They're a guarantor. All those issues. It seems like everybody did their specific job and nothing else. Do you think that is in compliance with the ethical implications of the professionals involved, whether they're attorneys or bond counsel or the financial analysts that were here, and just everybody?
Well, that's a very broad question to address. You'd almost have to take each professional and what their role was and examine it with respect to each of the financings.
Were any red flags raised by you during your time
Oh, yes.
on the case?
Yes, we put together the official statement for the 2003 transaction, and we put numerous warnings in that official statement. There is no way someone could buy that paper without seeing the potential pitfalls, the fact that there wasn't many of the points that you just made were all mentioned in the official statement in connection with the 2003 transaction. And in 2007, as bond counsel, we do have a reputation of being upfront and letting our clients know what the problems are.
Okay.
The 2007 deal was supposed to solve this problem.
Right, right. Well, thank you very, very much for your time today. I appreciate it.
You're welcome.